Yes, good afternoon. Welcome to another daily dose of Satoshi's News. Today's date is Tuesday, the 17th of October, 2023, the year of BSV. Buy BSV.live, the best place to buy Bitcoin SV online, the original protocol and genuine Bitcoin. Here we go, let's get into it. So today we're just touching on the same thing. We are going on about the largest court case in financial history. This is the cabal masquerading as COPA, going after Craig Wright, the creator and inventor of Bitcoin, trying to steal his intellectual property. So I'm literally just trying to explain to him what's going to happen when he goes into court. So as Jordan Atkins wrote in his piece yesterday, he said that Justice Mellor would be administering the case here. And this is an administration court because there is no jury. And it's the Bill of Rights that said there is to be no final forfeitures without conviction from a jury of peers. Actually, I should have found the Bill of Rights. But just to emphasize that, check this out. This is Halsbury's Law that I was trying to find yesterday. So it said, administrative courts unlawful, Halsbury's Law. Halsbury's Law states administrative courts are unlawful. The councils and the Child Safety Agency may want to read this. Check this out. It says, the law is absolutely clear on this subject. There is no authority for administrative courts in this country, and no act can be passed to legitimise them because of the constitutional restraints placed upon Her Majesty at her coronation. So in other words, in the Coronation Oath Act, administrative courts are absolutely unlawful. There's more down here where it says as well about being used for extortion. I'll just see if I can find it. The same bodies even purport to issue their own legal documents by tacit agreement with the courts. In our system of common law, the rule of law demands that we have a separation of powers. Today, the powers are not separated. The executive is not a distinct, freestanding leg of the tripod. The executive now merges directly from within the elected chamber of the legislature, where previously it emanated directly from the monarch. That leads to constitutional confusion because the executive has seized and misused Parliament's democratic credentials for its own destructive purposes. Fortunately, we have something to which we can turn to preserve our ancient laws and freedoms. We have the oath that Her Majesty the Queen took at her coronation, by which she is solemnly bound, and from which no one in England, Wales and Scotland has released her. At her coronation, the Queen swore to govern us according to our respective laws and customs. Certainly among our reputed customs is precisely that invaluable and widely admired tripartite division of the powers. The judiciary is part and parcel of our customary system of internal sovereignty. The Queen in Parliament, it is one of the three separate but symbiotic powers, and it is the capricious and self-serving contention that it should not have the power to preserve the authority of the legislator over the executive. It is a constitutional principle that the assent of the Queen and the Parliament is prerequisite to the establishment of a court which can operate a system of administrative law in Her Majesty's courts in England. This was confirmed by Lord Denning during the debates on the European Communities Amendment Bill on the 8th of October 1986. He said, there is our judicial system deriving from the Crown at the source and foundations of justice. No court can be set up in England, no court can exist in England by the authority of the Queen and Parliament. That has been so ever since the Bill of Rights, and that's 1688. It is literally the Bill of Rights. No final forfeitures without conviction from a jury of peers. Administrative courts have no powers whatsoever. And we can see here in the Practice Direction A5 Court Documents, under Supplying of Documents, which is what I pointed out the other day. See if we can find this. Here, look, supply of documents to court from court records. It has got here the Central Office of the King's Bench, and again we'll go over the bench in a minute, Chancery Chambers, and the Admiralty and Commercial Court Registry. So it is Admiralty and Commerce that go together, and I found a little video that will explain that more succinctly in just a second, which we'll get to. And this is what I want to point out here. The Crown Agents Bill, this is so important. So important because it explains what's happened. So in this it says here, in short, the bill provides... do all of that. In short, the bill provides for the transfer of the Crown Agent's business to a successor company under the Companies Act. And a company is a corporate entity. It is a corpse entity. It is a legal fiction, which means it has no authority whatsoever. Wholly owned by the Crown and therefore in the public sector. The bill also gives the Secretary of State the consent of the Treasury, the power to dispose of the successor company to a new owner, essentially privatising the business. It's private. It's nothing to do with government or the people. It's absolutely outrageous. And let's go to page 3. So let's have a look at this. The Crown Agents were first... Well, we'll leave that bit. Here we go. The Crown Agents were established as a statutory UK public sector, a corporation on the 1st of January 1980 by the Crown Agents Act 1979. This was the first time the Crown Agents were given legal status as a public corporation. Corporation. It means they have absolutely no authority whatsoever. And it says down here... one effect of the 1979 Act was that employees of a Crown Agent ceased to be civil servants. They're no longer civil servants. There are no Crown Agents anymore. If the Crown Agents is privatised in the next year or so, it will have spent only about 15 years of its 162 years as a public corporation. It is absolutely outrageous. And we go down to 27, 28. Here we go. Look at this. So it says here... government will reconstitute Crown Agents as a company under the Companies Act and transfer full ownership of that company to a foundation. Under these arrangements, Crown Agents would continue their business activities on a fully commercial basis. It is commerce. It is admiralty law. It is absolutely outrageous. It is criminal. It is unlawful. Absolutely unlawful. So let's just go here to the statutes and monopolies that I mentioned the other day. Look at this. All monopolies and grants thereof of dispensations and penalties declared void because we are all equal in the law. Nobody has any special powers. And it says all monopolies and all commissions, grants, license, charters, etc. Within this realm or dominion of Wales or of any other monopolies or powers, liberties or faculties to dispense with any others are altogether contrary to the laws of this realm. And so are and shall be utterly void and of non-effect. Non-effect. It's absolutely outrageous. So just to show you, well, actually, I'm going to introduce you a video here to Jordan Maxwell who explains this really well. So here we go. Sit tight, have a listen.
There are two kinds of law on the earth, as I've said. One is called civil law, which is the law of the land, and one is called maritime admiralty, which is called the law of water. Maritime admiralty is banking law, and the law on the maritime admiralty says that you, because you came out of your mother's water, are a maritime admiralty product. This is why the ship is sitting in its berth and it's tied to the dock, and the captain has to give a certificate of manifest to the port authorities because money is changing hands. This is why when you were born, you have to have a birth certificate. It's got to be signed by the dock because that's where the ship is tied to, is the dock. So the dock signs your birth certificate. Why? Because you came down out of your mother's water. You came down her birth canal. You are a maritime admiralty product, and therefore your birth certificate is signed by your mother. And where your mother signed on the birth certificate, get it, you will see it does not say parent or mother, it says informant. Your mother was informing the bank that she has just produced another product to be bought and sold. The British Crown, through international banking, owns your physical body, and that's the law.
So you go into a court. The whole idea of a court is like I said, basketball court is a game. This team stands up and throws the ball back in the other guy's court. And that team of lawyers throws the ball back in this guy's court. And the judge is going to rule from the bench. The word bench is a Latin word for a bank. So he's ruling for the bank. Why? Because somebody's going to have to pay their debt to society. Somebody's going to pay. When the day is over, somebody's going to lose and they're going to pay. extraordinary story about how governments rule the world. And unless you understand this, you're never going to figure out what's going on. Look at it. When you walk into a courtroom and they call your name, you get up and you put your hand on the gate and you open the gate. The moment you put your hand on the gate, by international law, you of your own volition have opened yourself up to maritime admiralty law, because you were on the law of the land. As long as you don't touch that gate and go through it, you haven't opened the floodgate. Now, once you open the floodgate, there's a piece of wood on top of that gate, and it's called the bar, and you're not licensed to pass the bar. Right. So what you've done is you've opened the floodgate, but you weren't licensed to pass the bar. Well, you're considered to be a dead man. You went into the deep water, and you died. You drowned. That's why the attorney has to speak for you. You were not licensed to pass the bar. And the bar represents a sandbar in the ocean. But the bar is what the attorneys are licensed to pass, but you're not. So the point being is that when you open that gate of your own volition, you are considered by law to be a dead man. That's why you cannot talk to the judge, because dead people don't talk to judges. So you need an attorney who is your mouthpiece. He speaks for you.
There we go. He said he speaks for you. Like there is no harm in going in there, in going into court, asserting yourself as a man. No harm whatsoever, because that is exactly what he is. He is a man asserting his rights as a man. Ownership, and as the inventor and the creator of Bitcoin. The scam is just absolutely huge. They are never going to, I don't believe they're ever going to sort of like just take this lying down whatsoever. And the only reason they can get away with it is because it is fiat currency. They are making it up. They're literally printing it out of nothing, which is why they can get away with what they're doing. So here's another explanation of how they use their system against us, and why it is so economically powerful for them. Have a listen.
Knowledge is power. Profound things have been said in the Bible. For instance, it is written in the Old Testament that my people are dying from a lack of knowledge. Banks do not loan money. There's a law in America that says no bank can loan money, period. That's the law. Now, how many people go to get a loan from a bank know that the law in America says no banks can loan money? How many people know that? The way it works is very simple. Suppose you're buying a $30,000 car, $50,000 car. That car, first of all, has to be appraised by a state-approved appraiser. So you have a government appraiser appraise the car for its value, and let's say it's $50,000. Therefore, the paperwork, which represents that $50,000 car, is referred to in commerce and business as commercial paper. And that piece of paper represents $50,000 in business. So what happens is if you decide you want to buy the car, the dealership sends the paper to the bank. So now the bank has a $50,000 worth of commercial paper. What the bank does is they open up a bank account in your name without you knowing it. All banks do this. They open up a bank account in your name. They sign your name on the bank account, because you can't open a bank account without a signature. So they sign your name on a bank account and open up a bank account for you. But you don't know that. Then they take the $50,000 in commercial paper, which represents $50,000, and they put it into your account. So now you have a bank account in their bank with $50,000 in it. And then they take that bank account and they write a check on that for you. So the first check for the first $50,000 they write for you, and they sign it for you and give it to you so you can give it to the dealer. So you think the bank has loaned you $50,000. No. The bank merely gave you credit on the commercial paper which they're holding. They are confirming that they have the $50,000 in the bank with the paper. They're holding the pink slip. Therefore, they will give you a credit of $50,000 based on your commercial paper. So they didn't give you anything. You gave them $50,000 on commercial paper. They just gave you a credit. And so that's the way it works.
There we go. And now you know. So this is all about the largest court case in financial history on the 15th of January 2024. Honestly, Calvin and Craig, if you're listening to this, if anybody else hears this, please share this video with them. Tell them about it so we can actually tell him what he needs to do that the barristers are not going to tell him. So hope they're listening. So until then, be aware, take care, stay safe out there, and we'll see you in the next one.